On behalf of the Institute of International Shipping and Trade Law, a research center within the School of Law at Swansea University, I would like to welcome you to the guest lecture, which will be delivered by Sir Peter Gross. This lecture was originally going to be delivered on 30th of March at Swansea to celebrate the 20th anniversary of the Institute. But like most things this year, it has become a casualty of the global pandemic. However, we refuse to be beaten to the virus. And after consulting with Sir Peter and also with the encouragement and support of our Executive Dean, Professor Elwyn Evans QC, we are delighted to offer the lecture as an online event. I'm grateful to Professor Evans, who will deliver the word of thanks at the end of the lecture. Following her recent promotion to Pro-Vice Chancellorship, she is extremely busy, but we feel her support at this school and the Institute all the time. The Institute was established about 20 years ago by Professor Gideon Thomas. And at the end of the first year, we had 3 members, namely Gideon, myself, and Professor Richard Williams. Today, it's a leading research center in Europe, specializing in commercial and maritime law with 18 members. And I am actually very proud to be the director of this magnificent center of excellence. I would like to acknowledge publicly the contribution made by our members and thank to our national and international partners, and of course, our university for their support. We are celebrating our 20th anniversary. And at this time, it would be a big omission on my part not to acknowledge and remember the contribution made by Dr. Theodora Nikaki, who we lost to a cruel disease in 2018. We miss her a lot. Sir Peter Gross needs very little introduction. He has enjoyed an eminent legal career spanning over 40 years. He acted as a legal counsel in many commercial and maritime disputes, and was appointed in 2001 as a judge to the Queen's Bench. He retired in 2019 as a Court of Appeal judge, in the process performing several significant roles in administrating our judicial system. He is currently working as an arbitrator at 20 Essex, and his talk tonight carries a very provocative title, The Judiciary Today, the Least Dangerous Branch. And I'm sure everybody is looking forward to his impressive analysis on our judicial system. Ladies and gentlemen, it's my pleasure to invite Sir Peter to deliver his talk. We shall take questions at the end, so please send your questions using our, actually Zoom's, Q&A function. Thank you very much, and Sir Peter, the floor is yours.
Executive Dean and Pro-Vice Chancellor, Professor Sawyer, it is a great pleasure to be here today, albeit virtually, to deliver this Institute of International Shipping and Trade Law, Swansea University public lecture. Thank you, Professor Sawyer, for the very kind words of welcome. It is an honor for me to do so for a number of reasons. First, it is the centenary year for the university. Secondly, I'm acutely conscious of the distinguished lecturers in previous years, including, but by no means confined, to Lord Clerk of Stone-cum-Ebony. Thirdly, I have previously participated in 2 excellent colloquiums organized by the Institute of International Shipping and Trade Law. Fourthly, it is a matter of great personal pride that over the period 2013 to 2015, I was senior presiding judge for England and Wales. Adopting the timeless expression of Alexander Hamilton, my topic is the least dangerous branch, the judiciary today. As Hamilton put it, the judiciary has no influence over either the sword or the purse. It has neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. My focus is on the relationship between the judiciary and the other branches of the state, a subject of significant and continuing scrutiny. I also seek to underline the immense role the judiciary must and can play in the post-pandemic and post-Brexit world. The views expressed are my own. I advance 4 principal propositions. First, mutual respect between the 3 branches of state, the legislature, executive, and independent judiciary, is of the first importance. Secondly, the fact of parliamentary or executive distaste for a particular court decision or line of decisions does not, of itself, furnish guidance for a sound policy response. Thirdly, the traditional virtue of judicial reserve or restraint should be retained as an institutional strength. Fourthly, the brand of the English judiciary is internationally acclaimed and forms an important part of global Britain and the United Kingdom's soft power. Nothing whatever should be done to weaken it. Instead, it should be maintained and strengthened. An exclusively current and domestic focus is too limiting. Before, therefore, developing these propositions, it is helpful to stand back and turn to the remarkable saga of the failed attempt by the great US President, Franklin Delano Roosevelt, FDR, to pack the US Supreme Court, arising from frustration over the court's repeated striking down of New Deal legislation in the 1930s. In passing, that episode further serves as a reminder that recourse to labels is simplistic. So today, the temptation is to categorize interventionist, or in quotation marks, activist judges as, quote, progressive, and those favoring judicial restraint as, quote, conservative. However, in the USA controversy of the 1930s, the exact opposite prevailed. So-called progressive judges favored restraint and deference to the legislature. Conservative judges were interventionist in defense of what they saw as the encroachment by the New Deal legislation on rights of property and contract. Beware labels. The background to the court packing attempt was graphically outlined in the biography of Chief Justice Hughes, US Chief Justice at the time. Quote, "The most dramatic and far-reaching struggle involving the court came over the use of federal power to control the national economy. The Depression of the 30s had thrust upon the government numerous obligations that it had never before assumed. Swept into office on a pledge of drastic action, President Roosevelt had launched a series of bold experiments with little regard for the limits of federal power. From the first days of the New Deal, it was obvious that our constitutional system was undergoing a wrenching such as it had not experienced since the Civil War," end quote. In 1935 and 1936, the Supreme Court struck down 2 signature reforms of the early New Deal, the National Industrial Recovery Act and the Agricultural Adjustment Act. It has been said of the first decision concerning offences involving the sale of an unfit chicken to a butcher that the offences had about as much effect on interstate commerce as a mosquito on a herd of elephants. Other similar decisions followed, typically by a majority, in which it was at the least perceived that the court favoured rights of property and contract over the social policy underpinning the New Deal. November 1936, and FDR was re-elected to his second term as president. Flushed with political success, FDR stunned his own party's congressional leadership and the nation when on the 5th February 1937, after discussions with only a tiny circle of advisors, he launched the court packing plan in a special message to Congress. FDR felt that the court was thwarting the national interest. The judges could not be dismissed as they enjoyed lifelong tenure. FDR could have sought a constitutional amendment enlarging federal powers, but was unwilling to wait, given the time it would have taken. Nor was he attracted to other options, such as a statute limiting the court's jurisdiction or a law requiring more than a majority vote to nullify an act of Congress. Instead, he proposed to enlarge the court's membership. He sought power to nominate a new justice for every sitting justice over the age of 70. So, as was remarked, curiously equating age with incompetence, or at least hostility to the New Deal. The effect would have been to increase the court's membership from 9 to 15. The measure was initially presented as intended to relieve the courts of congestion and avoid injustice. The Supreme Court, FDR suggested, was laboring under a heavy burden. Initially, it was assumed that the president's sweeping election victory meant he would prevail. Then, quote, across the country came a rumble of protest, unquote. An adroit campaign of opposition was mounted, resulting in the leeching of otherwise loyal support for the president and the New Deal. For its part, the Senate Judiciary Committee decided to avoid haste and permitted 2 months of deliberation. As the debate continued and America's Senate and people had a chance to think it over, initial enthusiasm began to diminish. The justices took the view that they would not appear before the Senate Judiciary Committee. However, they intimated that they wished the committee to have an authoritative statement of the facts as to the state of the court's workload. In the event, over a weekend, a letter from Chief Justice Hughes was prepared, approved by 2 other justices. It was read to the committee at its hearing on Monday, the 22nd March, with dramatic effect, described as a bombshell. The somewhat colorable FDR story that court packing was necessary to relieve the burden on the court and to assist it in coping with the workload was holed beneath the waterline. It was the beginning of the end, though the end was some time in coming. More was to follow. In 1936, the court had struck down a New York state minimum wage law by a 5-4 majority, with Justice Roberts casting the deciding vote. However, on 29 March 1937, the court dramatically gave judgment upholding a Washington state minimum wage law by a 5-4 majority, with the same Justice Roberts casting the deciding vote for upholding the statute. Whether the court altered its view in response to pressure from the Roosevelt administration, encapsulated in the memorable phrase, "the switch in time that saved 9, or whether the court packing plan had no bearing on the outcome, almost matters not at this remove. The fact is that the tide in the court had turned, itself further undermining the court packing plan." Subsequently, other, quotes, progressive state legislation was upheld by the court. One of the, quotes, conservatives on the court retired in May 1937. The Senate Judiciary Committee voted 10-8 against the bill. On the 13th July 1937, the then majority leader in the Senate, who had been an ardent supporter of the proposal and to whom a seat on the court had been promised by FDR once vacant, died of a heart attack. The end finally came on 22 July 1937, when the Senate sent the bill back to committee with a commitment that it would not be reintroduced in that session, described as sending the bill to oblivion. Various lessons emerge. The first goes to the real danger of underestimating public disquiet at a serious threat to the independence of the judiciary and the rule of law, whatever first blush appearances. Once the true motive for the bill emerged, it became clear that FDR had unusually overplayed his hand. As has been said, the court was a sacred symbol in the American covenant. A direct assault was the political equivalent of sacrilege. Secondly, as another writer has observed, had FDR waited only a little longer, he could have had victory without paying such a heavy political price. Thirdly, and at least equally importantly for present purposes, assuming that the Supreme Court had overreached itself in opposition to certain New Deal legislation, the law, on this assumption, had righted itself. FDR had indeed only needed to wait a little longer. I return to my propositions. First, there is an unanswerable case for mutual respect between the three branches of the state, avoiding institutional overreach. That is not a call for abdication of the judicial function or pusillanimity, nor is it an assertion that all judicial decisions should be uncritically approved. Moreover, some tensions between the branches of the state are unavoidable and in a democracy healthy. My proposition means what it says. The state and its citizens are best served when mutual respect prevails between the three branches, each avoiding institutional overreach. Disagreement is one thing, lack of respect is another. In this context, it is noteworthy that mutual respect has been and remains a hallmark of our constitutional arrangements. In 1992, Lord Justice Nolan, as he then was, elaborated on the nature of the relationship between the courts and the executive. The careful constitutional balance struck, one which is inherent in our commitment to the rule of law, as he explained, was one that required the, quote, courts to respect all acts of the executive within its lawful province, and which saw the executive respect all decisions of the courts as to what its lawful province is, end quote. This takes me to my second proposition. The fact of parliamentary or executive distaste for a particular court decision or line of decisions, hardly remarkable, does not of itself furnish guidance for a sound policy response. On any view, knee-jerk responses can be ill-advised. Simply by way of example, in the immediate aftermath of the controversy occasioned by the Supreme Court's decision in this country in the second Miller case concerning prorogation, voices were heard calling for US-type confirmatory hearings for senior judicial appointments. But this country has no such tradition. And for my own part, I would be dismayed were such hearings introduced. It would be wise to beware what one wishes for. Partisan proponents of any such course need to reflect on how matters would look under a government of a very different persuasion from that which they favor. In any event, it would inevitably introduce a party political coloring to judicial appointments. It is a feature of the current English judiciary, and I should say the judiciary of England and Wales, I only say English by way of shorthand, that our system has not been politicized in any such fashion. From personal experience, it was a significant strength of our courts that colleagues did not know the party political views of those with whom they sat. And it goes without saying, I never encountered a case where the decision was influenced by, let alone hinged on, matters of party politics. All this is not to say that careful deliberation is not appropriate. If there is a valid case that boundaries have been overstepped by any of the branches of state, a variety of options are available, including wait and see, statutory correction, and calm and measured consideration by way of independent review. I start with wait and see. Staying with the second Miller case, some suggested that the court overstepped the mark. For others, it was no more than the application of well-established principles through which the courts considered whether the executive had gone beyond its lawful boundary. Over time, its true scope will become apparent. For those concerned or alarmed by the decision, there is time and room to wait and see. As already discussed, had FDR waited just a little longer, he need not have embarked on the ill-fated court packing plan. There is indeed a very great deal to be said for leaving matters to time and the common law method. The common law evolves as circumstances change. That is how it retains its relevance. Judicial tides ebb and flow. From time to time, it advances and then retreats. Changes can be made. I come next to statutory correction. There is, in any event, in our jurisdiction, England and Wales, a safety valve. By reason of parliamentary sovereignty, common law developments can always be reversed by statute. So if, for instance, Parliament concludes that the principle articulated in Miller is one that needs correction, it has the power to reset the balance between the three branches of state. As with any legislative developments, the steps Parliament takes will then be subject to scrutiny and democratic accountability. Such developments are not so easily taken in the US, where, for instance, a decision of the US Supreme Court is considered to be in need of resetting. It may require a constitutional amendment. Such amendments are rare and far more difficult to secure than an act of Parliament. The judiciary here is indeed the least dangerous branch. There can be no principled objection to statutory reversal of a court decision or lines of decisions of which Parliament disapproves or considers in need of course correction. That approach is therefore open, though it too requires careful thought. Legislation can be a blunt instrument and carries the risk of focusing on what might be termed the last war rather than the next, with the inherent risk of unintended consequences. An additional variant is the noteworthy approach of the present government in commissioning a number of reviews of different aspects of the justice system. Provided such reviews are independent, credibly constituted, and conducted in a calm and measured manner, no proper objection can be taken to them. To the contrary, they facilitate a rounded, contextual consideration of their subject matter. The first of these reviews is the Independent Review of Administrative Law, IIRAL, launched in July 2020 to consider options for reform to the process of judicial review. As provided by its terms of reference, IIRAL, chaired by Lord Fawkes, Queen's Counsel, should examine trends in judicial review of executive action, in particular in relation to the policies and decision-making of the government. It should bear in mind how the legitimate interest in the citizen being able to challenge the lawfulness of executive action through the courts can be properly balanced with the role of the executive to govern effectively under the law. This is very much an area where the boundaries between law and politics can be troubling and are capable of giving rise to constitutional tensions. Notably, issues of justiciability are included in the IIRAL terms of reference. The balance struck by IIRAL will be of obvious importance, given the values and interests involved, some of a fundamental nature. That brings me to the second review, the Independent Human Rights Act Review, or IRA. I declare an interest, as at the request of the Lord Chancellor, I have accepted the invitation to chair it and am delighted to do so. I should mention that, quite coincidentally, IRA launched today. So this is my first mention of it. That IRA launched on an important day in the Brexit negotiations is, I should underline, wholly coincidental. IRA is Brexit neutral, not being concerned with Brexit, the European Union, or the court in Luxembourg. I underline that IRA is deliberately so named. It is and will be an independent review. As the Lord Chancellor said recently when appearing before the Houses of Parliament Joint Committee on Human Rights, this will be an independent process of mature reflection within the context of enhancement and protection. The conclusions of the panel, whose members have been selected on the basis of their wealth of experience and coming from a variety of senior legal and academic backgrounds, are in no way preordained. The review will be UK-wide. It is concerned with the operation of the Human Rights Act 1998. Its remit does not extend to the European Convention on Human Rights, of which the United Kingdom is committed to remain a signatory. The UK's contribution to human rights law is immense, founded on the common law tradition, continued with the UK's contribution to the drafting of the Convention, and more recently to the enactment of the Human Rights Act. The Human Rights Act has now been in force for 20 years, and it is timely to review its operation, constituting, as it does, so important a part of the legal framework of the United Kingdom. As set out in its terms of reference, IRA will look at two key themes. One, the relationship between domestic courts and the European Court of Human Rights. Two, the impact of the Human Rights Act on the relationship between the judiciary, the executive, and the legislature. IRA will consider the approach taken by domestic courts to the jurisprudence of the European Court of Human Rights, including how the duty to take that jurisprudence, quote, into account has developed, and the possibility of strengthening the dialogue between domestic courts and the European Court of Human Rights. It will consider whether the Human Rights Act strikes the balance between the roles of the courts, the government, and Parliament. Moreover, it will consider whether the current approach risks domestic courts being unduly drawn into questions of policy. The panel will then consider whether, and if so, what reforms might be justified. As part of its work, IRA will also examine the circumstances in which the Human Rights Act applies to acts of public authority of the implications of the current position and whether there is a case for change. Though very much a decision for the panel itself, it is likely that the panel will in due course call for evidence and views, and it is hoped will receive a range of contributions. It is intended that the panel will report to the Lord Chancellor in the summer of 2021. Its report, very likely couched in terms of options rather than binary recommendations, and the government's, its report, the panel's report, and the government's response will be published. For tonight's purposes, it may therefore be seen that an important part of IRA is concerned with the relationship and the balance struck between the three branches of the state. There is, furthermore, some discussion of a review to consider reforming the Supreme Court. As yet, at least, I am not aware whether this has gone beyond the realms of discussion. though it has earlier this year generated 2 papers produced by the think tank Policy Exchange, together with an interesting foreword by the Right Honourable the Lord Thomas of Cwmgyrth. It has also sparked vigorous criticism. We shall have to wait and see. Above all in this context, whether considering statutory reversal of a court decision or line of decisions, or reviewing aspects of the justice system, there is the acute need to keep in mind babies and bathwater. Hence the clear distinction between parliamentary or executive distaste for a court decision and a sound and considered policy response to it, founded on mature reflection. Our judicial system is simply too valuable a national asset in every sense to pursue a remedy in haste, which will do more damage than the mischief at which it is aimed. This takes me to my third proposition. Mutual respect and the avoidance of institutional overreach cuts both ways. The traditional virtue of judicial reserve or restraint should be retained as an institutional strength. Judges cannot be criticized for deciding matters of public controversy. That is part of the judiciary's role, emphasized when the legislature outsources to the judiciary open-ended political, moral, or social questions, especially when a social consensus is lacking. But it is no part of a judge's role to court public controversy, and judges ought not to be seen as celebrities. That the identification of a recently appointed Supreme Court Justice, whose initials were given as PS on the BBC programme Pointless, yielded a pointless answer, no member of the public was able to identify the judge's name from those initials in the game, certainly and happily suggests that judges generally remain far from being celebrities. For those interested in the answer, it is Lord Sales, JSC. Plainly, in our common law system, judges do develop the law, so facilitating adaptation to changing circumstances and ensuring the law's continued relevance. The fiction that judges merely declare the law is no more than that. There is, however, a line between legitimate judicial development of the law within the proper ambit of the common law method and unwarranted judicial lawmaking. That there is no single bright line and that the line is elusive does not mean that it does not exist. Judgment and judicial leadership are required to stay on the right side of that line. Judicial literature is replete with cautions in this area. So Lord Devlin argued powerfully against judicial lawmaking in advance of the social consensus, a fortiori in the field of statute law. As he put it, the keepers of the boundaries should not be amongst the outriders. For good measure, he added that, quote, enthusiasm is not and cannot be a judicial virtue, close quote. As so often, Lord Bingham provided guidance, highlighting a number of cautionary road signs which ought to give aspirant judicial lawmakers reason to pause. Further, even where a change in the law was called for, the judge would be well advised to walk circumspectly. As Lord Bingham put it, on the whole, the law advances in small steps, not by giant bounds. Much more recently, Lord Sumption has explored the place of law in public life, posing questions as to the expanding empire of law and the decline of politics. None of this is to say that legitimate judicial development or reform of the law is to be deprecated. To the contrary, it is essential in a common law system. The law of tort, to give but one example, was transformed by judicial decision. It is fanciful to imagine Parliament giving time to questions on assumed facts concerning a snail in a ginger beer bottle. In considering the judicial role, however, it is important to have regard to comparative institutional competence, to democratic legitimacy, and to the acceptable limits of unelected power, matters which underline the importance of judicial reserve or restraint, even allowing for the safety valve of parliamentary supremacy. I turn to my fourth proposition. The brand of the English judiciary is internationally acclaimed and forms an important part of global Britain and the United Kingdom's soft power. Nothing whatever should be done to weaken it. Instead, it is to be maintained and strengthened. Any controversy between the three branches of the state cannot and must not be allowed to distract from the major role which the judiciary has to play in the post-pandemic and post-Brexit time ahead. Internationally, the reality is that the English judiciary is held in the highest regard. That is, of course, no warrant for complacency, and it is certainly not said in any form of arrogance. But it is an accurate statement of which we should not be shy. Principally, such regard flows from the English judiciary's independence, impartiality, integrity, and expertise. The Commercial Court, for instance, this year, celebrating its 125th year, welcomes litigants from all corners of the globe. There is no home ground advantage. Such independence should be neither weakened nor curtailed. It is a cornerstone of the judiciary's reputation internationally, and the judiciary is the cornerstone of legal UK. English law and London as a centre for international dispute resolution remain world leaders. There is no reason why that should change post-Brexit. Such a ranking cannot, however, be taken for granted. Much work needs to be done, building on the mutually supportive relationship between the English court and the dynamic world of London arbitration. The international dispute resolution market is highly competitive. The figures involved are striking. Thus, the United Kingdom legal services sector posted a trade surplus of nearly £6 billion in 2019. In that year, total revenue from legal activities in the United Kingdom was £36.8 billion. Considered in financial terms alone, the importance of maintaining and strengthening a world-class independent judiciary with its pivotal role in the sector must be obvious. A noteworthy development in 2020 has been the courts and judiciary's strikingly effective response to the consequences of the COVID-19 pandemic. The Commercial Court, again for instance, has moved at great pace to adopt the use of technology, which could facilitate remote hearings, that is, hearings where some or all of the participants are not in a physical courtroom. This included, in one early instance, a commercial dispute live streamed across the internet. This year also saw the first use of the innovative financial markets test case procedure to provide clarity in the insurance market in respect of matters arising from the pandemic. Both in terms of the use of technology and of innovative court procedures, the UK has a firm basis in the years to come to continue to provide ready access to high-quality justice. Matters do not end there. Under the unifying umbrella of the rule of law, the English judiciary engages in a wide range of international activity, both multilateral and bilateral. The importance of the rule of law simply cannot be underestimated in terms of strengthening or building institutions in challenging environments. Judicial diplomacy builds bridges between the English judiciary and the judiciaries of other states to the benefit of all parties concerned, so enhancing global Britain, UK soft power, and the national interest. the independence of the English judiciary is a necessary condition for and fundamental to its international role. Finally, it is necessary to the protection of London and English law abroad that our judicial system domestically moves with the times. As to infrastructure, the commercial court cannot be an island, succeeding alone while other courts flounder. The system-wide reform program must be driven to a conclusion, realizing the benefits on offer in terms of modernizing the delivery of justice and building on the acceleration of the use of technology in court, so effectively demonstrated in the response to the pandemic. In terms of substantive law, English law must adapt and is adapting, notably in the area of fintech, smart contracts, and the like. That is all to the good and very much to be welcomed. Conclusion. I end where I began. Our judiciary is world-class and independent, but the least dangerous branch does not exist in isolation. Justice and the rule of law require a shared effort between all three branches of the state. By avoiding distractions and damaging unnecessary conflict between those three branches, while recognizing the inevitability of occasional and recurring institutional tensions, continuing emphasis can be placed on the judiciary's key role in improving the delivery of justice domestically, together with maintaining and enhancing the position of English law and London internationally in the post-Brexit years ahead. Thank you very much.
It gives me enormous pleasure to thank you, Sir Peter, for your superb analysis. The 4 points you identify so effectively identify core values of our judicial system that it's a really, really fantastic way of approaching the topic and spending time looking within it. And I'm very much hoping that there will be a publication of your lecture, Sir Peter. It really is very rich and very, very valuable. It is a pleasure, it's a privilege to welcome you remotely to Swansea. I know for lots of people, Swansea may feel somewhat distant, but in fact, I was delighted to hear you refer to two people in the course of your lecture, the Lord Chancellor, who hails from Llanelli, which must be about 10 miles or so to the west of Swansea, and Lord Thomas of Cwmgiev being some 15 miles to the north of Swansea. So in fact, Swansea sits at the heart geographically, if nothing else, of your analysis and lecture today. I do so look forward to being able to welcome you in person. You've been a fabulous supporter of our community in Swansea and in particular of the Institute. And I, as ever, wish to extend my gratitude to them for all they do, all their support, their wonderful research and their engagement globally with the shipping and trade work that they so well understand. I'm just going to finish, if I may, and it's rather a long list, but it's a list of some of the roles that you, Sir Peter, have held. And it goes to show what a fabulous platform you speak from in analysing the judiciary, but also how privileged we are that you have been willing to bring your analysis of such an important part of our legal system to us tonight. Of course, Barrister Silk Bensher, Recorder, High Court QBD, Commercial Court, Presider on the South Eastern Circuit, which is of course the biggest and the most populous circuit, the Judge in charge of the Commercial Court, Judge of the Special Immigration Appeals Commission, Chairman of the Committee on Judicial Security. I have to confess, I'm not sure what that is. So when you do come to join us, that's one of the things I'm going to be asking you in any dinner that we have together. A Lord Justice of Appeal, of course, from 2010. Deputy Senior Presider and then the Senior Presider, major role within the judicial system. A lead judge for international relations, retired. But of course, there is no such thing as a retired judge. And then arbitrator, and we are delighted at your appointment by the Lord Chancellor announced today in your role as the lead of the panel on the Human Rights Law Review. Congratulations, I can think of no better lead for such a panel. And indeed, if we need look no further than the sensitivity of your answer to the questions asked today, where perhaps some were just seeking to see whether they might get some sort of little hint of your direction of travel. Absolutely not. What subtle political acuity you display. So thank you so very, very much. And please come and join us in Swansea as soon as ever we return to whatever the new normal is. Thank you, Sir Peter. We're very, very grateful.
Thank you.